going to skip the Seventh Amendment, which is about civil cases, and jump to the Eighth Amendment as we continue to look at defendants' rights. And the Eighth Amendment pertains to individuals who have been convicted of crimes. And the Eighth Amendment, of course, specifically protects against cruel and unusual punishment. The problem is the Eighth Amendment does not define what constitutes cruel and unusual punishment. The Supreme Court at this point has ruled that the death penalty is not cruel and unusual. We have two cases for that, Gregg versus Georgia in 1976 and McCleskey versus Kemp in 1987. And in both of those cases, the Supreme Court upheld the death penalty as constitutional and not in violation of the Eighth Amendment. It is time for an attention check. Our terms for today's attention check will be orangutan, gibbon, and macaque. Don't worry about the spelling of macaque. I think you will recognize it when you see it in the question. Back to the lecture. On the other hand, who can be executed does face restrictions, constitutional restrictions, according to court rulings. You cannot execute mentally ill persons. This was established by Ford versus Wainwright in 1986. If you're thinking the name Wainwright, let's take a step back there. It's a missing W, the second W in Wainwright. Mentally ill persons, again, cannot be executed. If you're wondering if the Wainwright in Ford versus Wainwright from 1986 is the same one from the 1963 Gideon versus Wainwright case that is an AP required Supreme Court case, it is. Both cases involved as the respondent Louis L. Wainwright. Persons who would meet the standards of being a mentally retarded person, we put this in quotes, whether or not that label is still considered socially acceptable, that is legally part of the ruling, and therefore, given the precision that is required in legal language, that is still the term that is used. People who are deemed to be mentally retarded persons are not to be executed. And that case is not that long ago, back in 2002. People who were minors under the age of 18 at the time they committed the crime for which they have been convicted also may not be executed. This is as a result of Roper versus Simmons in 2005. And persons whose crime did not kill the victim may not be executed. This was decided in the case of Kennedy versus Louisiana in 2008. It was a very serious crime, but it did not result in the death of the victim, and therefore the Supreme Court ruled that Louisiana could not apply the death penalty in that case. Death sentences also have constraints in terms of their procedures. For one thing, as a result of Ring versus Arizona, another 2002 case, judges do not have the discretion to decide whether the death penalty is warranted. That is up to the juries, right, who have convicted a person of what is a capital offense, again, which is an offense that could be subject to the death penalty in sentencing. Rompilla versus Beard in 2005. This is also about procedure in terms of legal malpractice, I suppose you might think of it. If a defense attorney does not reasonably fight against the death sentence for their defendant or for their client, that could rule out the death penalty. And you're wondering why that might be the case. It could be for a variety of reasons. Okay? And obviously that one would be subject to lots of scrutiny in terms of what does and does not constitute reasonably fighting against the death sentence for a client. There are some other things to keep in mind. One, the continued use of the death penalty is uncertain. Executions have generally been on the decline. Executions used to be something that were conducted by local jurisdictions. This gallows is from the Patee House Museum. If you look here, this was built, it was meant to be a scientific improvement upon methods of execution by hanging, and yet it was not used because the law changed and local jurisdictions were no longer allowed to impose and carry out death sentences. Things have also changed. This picture is from the Missouri State Penitentiary down by Jefferson City. I suppose it is in Jefferson City. This was a gas chamber. It's apparently a famous gas chamber because Missouri efficiency being what it is, we decided it was cost effective to be able to execute 2 people in one gas chamber at the same time. But that is part of a museum now because it is no longer in use. There's been more of a shift towards lethal injection. I still remember being, as a much younger person, executions conducted still by firing squad in some states. I believe it was a state in the Southwest. It's the last one that I remember. And there are other constraints on the death sentence by lethal injection, especially. Apparently, the drugs that are used for it are kind of niche products, as you might imagine, and some of them are produced by foreign suppliers, and some of the governments in the countries whose businesses supplied those drugs have said they are not allowed to be exported to the United States because they are used for the death sentence. One of our last topics here is going to be one of the trickiest, and that is a right to privacy, which seemingly everyone imagines that they have, and yet it is on the shakiest footing. And in a legal sense is usually not as strong as people imagine. And it is certainly not as clear as is often thought. For one thing, in the Bill of Rights, there is no explicit mention of a right to privacy. You might be thinking, well, what about the Fourth Amendment? And that is always where my mind goes to. Protections against unreasonable searches sounds like a right to privacy, and it is in a very restricted sense in terms of searches requiring search warrants or, again, good reason that a search must be conducted immediately due to the risk of, example, loss of evidence. But in a broader sense, and beyond just the world of criminal law, the rights to privacy that you have legally in the United States come out of Supreme Court rulings that are based on the Bill of Rights. And it's going to be in areas you might not expect. Griswold versus Connecticut in 1965. And this one requires a longer excerpt so that you can kind of understand this. This ruling said that people have married couples, it was specific to married couples, have the right to buy contraception, birth control, and because of a right to privacy. So the court said, while the court explained that the Constitution, this is actually not what the court said. This is kind of a summary of a very convoluted and dense decision, but this is interpreted by expert people at OIES in 2026. While the court explained that the Constitution does not explicitly protect a general right to privacy, the various guarantees within the Bill of Rights create penumbras or zones that establish a right to privacy. This is language. This kind of basically says you have to tilt your head to one side and squint just right in order to see these zones of privacy. A penumbra is this kind of shadow area that we think of usually in terms of like a lunar or a solar eclipse, where there is the direct shadow of the moon that becomes narrower, and then the penumbra that becomes wider. So that bit of semi-shadow that kind of extends out around the edge of the moon from light that is not fully obscured. think I've got that right. I am not an astronomer and would not pretend to be one. I can find the North Star and the Big Dipper, and as an old Boy Scout, that is about all I have ever needed to do. So, we're talking about a shadow of a shadow, perhaps, that establishes a right to privacy. And the objects, right, that cast that shadow are the First, Third, Fourth, and Ninth Amendments. And remember, the Third Amendment is about quartering of soldiers. So the Supreme Court kind of dug deep into the Bill of Rights to find these penumbras or zones that establish a right to privacy. And so, kind of, for what in the world should you remember, because I do not want you to try and memorize that whole excerpt, those zones of privacy are derived from the shadows of those other protections. I think that is probably the best way for students to think about that. It's certainly how I think about that. And again, this was a narrow ruling that said married couples specifically had the right to use contraception because of their right to privacy. The same principle of privacy was then extended in the case of Roe versus Wade, which provided federal protections for abortions in the first trimester of a pregnancy. And that becomes perhaps the problem for rights to privacy, right? They become tied perhaps inextricably to the right to an abortion, the legal right to an abortion. Since then, there's been a mixed record on abortion between 1973 and 2002, so a span of nearly 50 years. In Webster versus Reproductive Health Services, 1989, the Supreme Court ruled that states can prohibit state money or state employees from being involved in the provision of abortions. Planned Parenthood versus Casey in 1992. This is I think that is seen as one of the central cases. And Whole Women's Health versus Hellerstedt in 2016. These cases, obviously Casey being first and Hellerstedt being a follow-on to clarify this, the upshot is states can regulate abortion as long as the limits they impose upon abortion do not constitute an undue burden on a woman seeking an abortion. And so there, lots of states kind of found this as it gave them room to experiment with different restrictions on abortion in states that were governed by pro-life officials. The big case we get, and I give you kind of this mixed court record just so that you can understand how the right to abortion was in some ways kind of not hemmed in, but trying to think of the best word to use for that, kind of modulated perhaps by the Supreme Court after the fact. And some of that leads us up to Dobbs versus Jackson's Women's Health Organization in 2022. This is the biggest case about abortion since Roe versus Wade because it overturned Roe versus Wade and Planned Parenthood versus Casey. For our discussion of rights to privacy, this is important because it calls into question the very notion that there are privacy rights derived from the Constitution. Whether or not the overturning of those two cases, and again, especially Roe versus Wade, will result in a constitutional right to privacy being further undermined in the courts remains to be seen, or could be undermined by law that might be challenged in the courts. So what I want you to understand, I don't have any solid conclusions here, but there is very much the possibility that that will start to unwind some of these other things that were in the penumbra, right, or the zone of privacy. To leave our discussion of civil liberties, we'll be moving on to civil rights. I'm going to leave this with some vital thoughts on a couple of notes. First, civil liberties and democracy. This ties back to things we learned at the very beginning of the year. in terms of notions of limited government, ideas that the government cannot do whatever it wants. It is subject to limits on its action and powers. Civil liberties are a source of limited government. And in terms of another of our big ideas, kind of constitutional principles from the beginning of the year, civil liberties, by their very nature, restrain majority rule. And there are things the majority simply cannot do on a whim because of constitutional protections of civil liberties. We also need to think about civil liberties and the scope of government. And the big point here is that civil liberties circumscribe or delineate, restrict the scope of government action. This is very much linked to the idea of limited government. There are things that are out of bounds for the government to do. On the other hand, the government may have to be quite vigorous in its action to uphold civil liberties. In terms of things like legal procedure, we can clearly see that. The Sixth Amendment's requirement that defendants have the right to a jury trial and the right for the government to pay for an attorney to represent them if they can't afford one for themselves. The massive court system and the very strained court system that we have that seeks to sort out these civil liberties issues, both to define the protections of rights, but also to ensure the protections of those rights against the government. A lot of government action goes into the subject of civil liberties. And so these aren't, we think about them as being for us as individuals, but we also need to understand them in the big picture of how they shape the relationship of all of the people to the government, and also affect what the government can and must do in the name of civil liberties. So that's an essential topic for those two related, but in some ways very different reasons. Again, after this, we will be moving on to civil liberties, and this concludes our look, civil rights. This concludes our look at civil liberties.